Our next case is Graziano versus Brater. Good morning. This is a 15-minute mini oral argument on the application. Both have 2 minutes of a free fire zone, which you may waive, and you have the opportunity to reserve time for rebuttal, but we ask that you keep track of your own time, please.
Thank you, Your Honor. Good morning, Your Honors. Matthew Arard here on behalf of the four plaintiffs' appellants. This is a case that concerns essentially the interplay between two statutes of the Michigan election law. The first being the statute that the plaintiffs sought to challenge in count one of their complaint, 472A, which prohibits the counting of any signature on an initiative petition if made more than 180 days before the date of filing. The second is 168.479, which concerns this court's original jurisdiction to hear challenges by persons aggrieved by a Board of State Canvassers decision involving the sufficiency or insufficiency of an initiative petition. And most importantly, whether 479 is triggered, therefore at minimum hinges on whether the sufficiency or insufficiency of an initiative petition constitutes the nature of the injury by which the person is aggrieved. Here, the plaintiff's injury did not arise from any decision as to the overall sufficiency of the petition they signed. Rather, their injuries arose from 472A's immediate and direct effect of barring their own petition signatures from being counted. Hence, they would have faced the same injury even if the Board of State Canvassers had found the overall petition sufficient. And thus, they do not bring their claim as persons aggrieved by a Board of State Canvassers decision regarding the sufficiency of an initiative petition, but rather as persons aggrieved by 472A's direct infringement of their own rights as electors and petition signers, a right that Michigan case law in DeLue versus Board of State Canvassers has held to be a cognizable legally protected interest. As to the question of whether 479 divests subject matter jurisdiction, this court, as this court stated in Paley versus Coca-Cola, the invariable rule is to resolve every doubt in favor of retention rather than divestiture of jurisdiction. Now, looking to the formulation of MCL 168.479, it is permissive as to the invited remedy, using the permissive may in the first section, being 479.1, and mandatory as to the process for pursuing that remedy, using the mandatory must in 479.2.
Counsel, can I interrupt and go back a little bit?
Yes, Your Honor.
Why would a person care if their signature is counted if the petition they signed is approved for the ballot anyways? What is it that they've lost out on?
I believe, Your Honor, that it's a form of expression, much the same way that a voter cares that their vote is counted, even if they vote for a losing candidate. And you know, arguably, the weight of a petition signature and its effect in bringing forth.
Let me just slow you down. So when you sign a petition, your interest is in expressing your view.
I believe so.
More than trying to get the subject of the petition advanced in whatever form it's supposed to be advanced in?
Well, if the United States Supreme Court has construed it to encompass both interests, there's a.
I mean, if you just want to express your view, even if your signature is invalidated, haven't you expressed your view by trying to sign the petition?
Well, not under 472A, because it prohibits your signature from even being counted. It's not even a matter of determining its validity or invalidity. It's simply excluded.
The question already assumes that the counting of your signature doesn't matter to the success or failure of the proposal.
I'm sorry, could you repeat that, Your Honor?
The premise of the question already assumes that the counting of your signature isn't material to the success of the proposal, right? So the counting of it, you said you have an interest. Once you get to counting, that has something to do with the success or failure of the petition, right?
Well, the Board of State Canvassers determines whether
If it's just expression, you've expressed your view on the petition by signing it, haven't you?
if it's not credited by the canvassing body.
So you need the government to credit your expression in order for that expression to be valid? That would be pretty oddly at odds with the First Amendment, would it not? The government has to endorse your speech for it to be a valid expression?
Well, I think if we look at U.S. Supreme Court cases, I think like Buckley versus American Constitutional Law Foundation, the crediting or whether signatures were creditable or whether circulators were permittable under the statute was found to implicate First Amendment concerns.
I mean, I don't disagree. There could be First Amendment concerns involved in this process. I'm just having a hard time following your argument that if the government doesn't count your signatures, that it somehow has negated your speech.
Well, Your Honor, I'm not sure that it is limited purely to First Amendment concerns either, but based on the case law of DeLieu, it is a legally protected interest in having one's signatures, as they put it, validated, invalidated, empowered, or disregarded according to established law.
Is it your position that the 180-day hard line is unconstitutional and it should return to the prior version of the statute where there was a rebuttable presumption, or that there should be no time limit or some other time limit?
Our position, Your Honor, is that the rebuttable presumption, the former iteration of 472A, would also be unconstitutional because it exceeds the legislature's power to enact. The justification with respect to constitutional amendatory petitions relied on a distinct provision of Article 12.2.
So there's no time limit?
No time limits other than the interval between gubernatorial elections, I believe.
Okay. And what do you do with the fact that as the record that we have now, I mean, isn't it a problem that almost 89% of the signatures are over 180 days? Do we know how many are all of them within the 4 years, though? Is that your position?
I believe, I'm not sure the precise date when the petition began circulating, but I think that's a likely result of grassroots campaigns when an initiative drive relies entirely on volunteers. The 1 to 180-day restriction creates a particularly acute burden.
What do you do with the fact that we have previously said that the 180 days, at least with the rebuttable presumption, is constitutional?
Well, Your Honor, I believe that you're referring to Consumers Power Company versus Attorney General, and in that case, this court specifically said that the basis on which the legislature was able to enact that provision with respect to constitutional amendments was the language of Article 12, Section 2, that summoned legislative aid in circulation and signing. That language is entirely absent from Article 2, Section 9. Thus, it would appear that Hamilton is controlling, which also concerned whether petitions were collected within a reasonable period, and there found that there was no summons of legislative aid. Article 2.9 is analogous to the constitutional provision at issue in Hamilton.
How does the statute obviously is tied, the signature amount is tied to the votes in the prior gubernatorial election. Does that mean there's like a 4-year time limit? Obviously, if there's another gubernatorial election and you're still gathering signatures, what number do you have to get then?
Your Honor, I believe that was addressed in a court of appeals decision, and the finding was that as long as the petition is filed before the date of the next gubernatorial election, then it's subject to the preceding threshold.
Okay, so could it be 50 years?
Well, the threshold, I think the threshold would change in the meantime. I mean, if the Board of State Canvassers delayed canvassing it for 50 years, I suppose, hypothetically, but I would think certainly
No, I mean for
petitions
like
of mandamus would be
gathering
in order.
signatures, like how long they could just, like, forever? I mean, I realize your argument is there's no restrictions on the time limit.
If they were not canvassed during that period, I think theoretically, Your Honor, but they would not be able to petition forever. They would not be able to collect signatures on opposite sides of a gubernatorial election. Looking to, it should also be noted that this is a declaratory judgment action. And under the Michigan court rules, the existence of another adequate remedy does not preclude a judgment for declaratory relief in an appropriate case. Contrary to the Court of Claims, the Court of Appeals declined to review the constitutional challenge brought by plaintiffs to 479's validity, apparently based on the assumption that it lacked jurisdiction and effectively finding that 479 precludes its own constitutional review. Given that the finding of 479 to bar subject matter jurisdiction over count 1 was the condition creating an actual controversy over the validity of count 2, the Court of Appeals' assumption that it lacked jurisdiction to resolve count 2 was clearly erroneous. However, given that this question would be rendered moot if this court finds that 479 did not bar the Court of Claims jurisdiction over count 1, this court need not resolve the propriety of the Court of Appeals abstention should it reach that conclusion. However, if the court does reach the Court of Appeals abstention as to count 2, we would urge that the court not merely remand to the Court of Appeals in lieu of resolving the remaining issues. For one, there's no fact-finding involved in this case or weighing of evidence that may render an intermediate court best equipped to have first review. Secondly, the trial court expressly declined to extend its declaratory judgment to the second sentence of 479-2, which was essential to the plaintiff's constitutional arguments. So whichever court reviews that challenge will in essence be taking a first pass at the actual substance of the argument that was made. If the court finds that 479 does, oh, I'm sorry.
Doesn't that, what you just said, it'll be the first pass, doesn't that kind of cut against your request for us to not remand it to the Court of Appeals? Shouldn't they take a first look at it?
Well,
They
I
haven't
think
weighed in on it?
I think that well, it was the Court of Claims that was given the first opportunity to review it, and I meant that given that the Court of Claims did not review it in full or review it with respect to the argument that was presented, it would essentially be reviewed freshly if by either court, whichever one was the one to review the Court of Claims decision. If the court finds that 479 does preclude jurisdiction over count 1, we would argue that it infringes this court's exclusive powers under Article 6, Section 4. Because this court cannot possibly comply with the mandate to give its highest priority to legal challenges under 479-2 without exercising its power of original review, the statute directly conflicts with this court's unqualified discretion over its exercise of its power to hear prerogative in remedial writs under Article 6, Section 4 of the Constitution. And with regard to the statutory requirements that this court advance such cases on the court docket, it similarly infringes this court's exclusive rulemaking authority under Article 6.5. The Director of Elections acknowledges the invalidity of these provisions, but contends that they are severable from the remaining statute. But unless we are to assume that the legislature would favor fully denying judicial review to Board of State Canvassers' decisions regarding initiatives in many or most instances, then it cannot be assumed that the legislature would have approved conferring this court exclusive jurisdiction without the ability to mandate its exercise. Notably, it appears that no court can issue a declaratory judgment regarding 472A under the Court of Appeals interpretation. As this court noted in Re Manufacturers Freight and Forwarding Company, this court's jurisdiction is fixed and defined by the Constitution. It cannot be expanded nor contracted by the legislature. And if we look to the convention comment for Article 6, Section 4, prerogative and remedial writs was intended to substitute for the list of historic writs under the 1908 Constitution, not conferring any new jurisdiction. So as this court held in Stevenson versus Golden under...
I'm sorry, your time's up.
Oh, I'm sorry.
Yeah.
Thank you.
Thank you.
Good day. Assistant Attorney General Eric Grill, appearing on behalf of the appellee, Director of Elections Jonathan Brater. I am joined at Council's table today by Solicitor General Ann Sherman. The main issue before the court today is whether the Section 479(2) of the election law provides deprived the Court of Claims of jurisdiction over the appellant's complaint. By its express terms, Section 479(2) applies to claims brought by persons who are aggrieved by any determination of the Board of State Canvassers regarding the sufficiency or insufficiency of an initiative petition. In this case, the claims raised by the appellants and in the manner in which they were raised sought to dispute the Board of State Canvassers' determination to reject the initiative petition filed by the Committee to Ban Fracking. Regardless of how the claims were styled, the complaint inescapably sought to challenge and reverse the board's determination as to the sufficiency of that petition. As such, 479, the claims fell squarely within the scope of Section 479(2) and outside the jurisdiction of the Court of Claims. In this application, the appellants have sought to avoid the plain operation of 479(2), first by arguing that the statute does not apply, and then second by saying that if the statute does apply, then it's unconstitutional. Respectfully, both of these arguments are incorrect. But before getting into those arguments, I wanted to highlight a fundamental flaw in the application. If all the appellants wanted to do was challenge the constitutionality of 472A, there were ways of them to do that without running afoul of 479(2). In fact, the Committee to Ban Fracking brought an essentially identical constitutional challenge to 472A in its petition for mandamus before this court, which it filed pursuant to 479(2), and this court denied that claim. So the statute is no obstacle to obtaining a constitutional challenge to this statute. More pointedly, if the appellants wanted to make what I would call a plain vanilla challenge to the constitutionality of the statute in the Court of Claims, there was no reason for them to wait until after the board made a sufficiency determination. And there was certainly no reason to wait until after the committee had finished its own legal challenge. They could have brought an action for declaratory judgment, seeking to clarify whatever right they claim to have in their signature at almost any time after signing the petition, provided that they did not implicate the Board of State Canvassers' determination of sufficiency.
Isn't that feels a little arbitrary to me? If you're challenging the constitutionality, what does it matter when you bring the claim? Like, so now because the Board of State Canvassers has taken a look, now we're into sufficiency territory? I mean, isn't it a constitutional question either way? It's
not solely limited to timing, but of course, filing requirements are not unusual, and you have to comply with them if you're going to bring your claims in the appropriate court. But in this case, the nature of the claims that they brought, they specifically sought not only declaratory relief, but injunctive relief, asking that the Board of State Canvassers recanvass the petition. So this was a challenge to the board's determination of sufficiency.
So because of the remedy that was requested, it puts it into the Board of Canvassers territory?
Correct. Also, even the allegations of the complaint specifically made allegations, I believe it was paragraph 10 of the complaint, alleging that the Board of State Canvassers applied for 72A, determined that the signatures could not be counted, and for that reason, determined that the petition was invalid.
So if they had just said, I just want you to declare the statute unconstitutional?
It would have been possible. Now, I think that if they wanted to bring a claim like that, I think they would still have needed to show standing and still needed to demonstrate a case or controversy, but a claim like that would have at least been within the jurisdiction of the Court of Claims.
And tell me why plaintiffs don't have standing here.
The plaintiffs, the issue wasn't standing in this case. The problem was they filed in the wrong court, and they filed almost a year late.
Okay. Do you think they have standing?
Yes, I think they have standing at least as to the complaint in this case. But the problem was, again, they filed in the wrong court, and they filed over a year late. Had they filed a similar action or an action in the Court of Claims without mentioning the Board of State Canvassers, I think it would have been possible to do so. But again, it's difficult to speculate on what they would have needed to show to demonstrate a case or controversy or standing, but it was definitely not what they did here. In this case, they specifically brought the board into it. They challenged the board's determination, and they expressly sought the board to make a different determination. There's no way to construe this claim as anything other than a challenge to the board's determination.
Okay, thank you.
Turning to the arguments of the application, the first argument they raise is that, well, 479-2 does not apply to us because we're only seeking declaratory relief. But again, it wasn't just a claim for declaratory relief. They sought expressly injunctive relief. Moreover, even where the complaint sought declaratory relief to declare that the 472A was unconstitutional, it did so in the context of attacking and undermining the board's determination as to the sufficiency of this petition. Importantly, 479-2 does not apply only to the board's ultimate determination as to the sufficiency of the petition. It specifically, according to the language of the statute, applies to determinations regarding the sufficiency of the petition. So insofar as the complaint here sought to challenge and attack the board's reasoning and say that the board was wrong to apply the statute, that is also a challenge to a determination regarding the sufficiency of the petition and likewise fell within the purview of 479-2. The appellants have also argued in this case that if 479-2 were applied, it would effectively preclude judicial review. Respectfully, that's not correct. Again, the Committee to Ban Fracking brought their own legal challenge, raising exactly the type of, in fact, an almost identical constitutional challenge to 472A. So it's not impossible, and it's not precluded by the operation of 479-2. Instead, 479-2 merely provides where and when claims of that nature must be filed. As we mentioned earlier, the plaintiffs, or the appellants in this case, could have filed a plain vanilla challenge to the statute at almost any time, and the Court of Claims would have had jurisdiction to entertain it, but it was plaintiffs' attempts to tie their challenge to reversing the court's decision that created the conflict with 479-2. Simply put, excuse me. The appellants have next argued that Section 479 is unconstitutional as a separation of powers or under due process grounds and that it deprives them of judicial review. Again, 479 does not narrow this court's jurisdiction, and it doesn't add anything to it that the court doesn't already possess. Article 6, Section 4 already provides this court with jurisdiction over prerogative and remedial writs, such as claims for mandamus. And it does not bar judicial review because, as we've noted, the Committee to Ban Fracking itself brought its own identical claim. Regarding the arguments to the constitutionality of 472A, those have never been addressed by the lower courts. I would urge this court not to do so for the first time here on this appeal. If the court feels that there was some claim that the Court of Claims had jurisdiction here but did not, I would ask this court to remand it back for further proceedings. But for the reasons stated, we would ask the court to deny the application. The court has any other questions?
I don't see any questions. Thank you both. The case will be submitted.